City of Natchitoches versus Travis Hines. Sir, are you here on this matter?
Yes, Your Honor. We're here on the motion to quash.
Certainly. Come forward. Your motion's first. So we'll wait until Mr. Benjamin is in the courtroom. All right, Mr. Benjamin's not in the courtroom, but this is your motion. You're here on behalf of Gold Weems, is that right?
Yes, Your Honor, we're here on the behalf of the City of Natchitoches.
And what is your name, sir?
My name is Morgan Briggs.
I believe you signed the petition or the motion.
The motion, yes, Your Honor.
Today we have 3 motions set before us. The first is filed by your office, sir. That's the motion to quash the subpoena Owsley's tecum. The second is a motion from Travis Hines, in limine to suppress certain evidence. The third is a motion to suppress witness statements. I'm going to handle the first one first, and then Mr. Benjamin and Mr. Hines, you can argue over the second one. So it's your motion, sir. Go ahead.
Real briefly, Judge. The subpoena Owsley's tecum that was issued requested 3 things. It requests police policies, it requests specific training information of certain police officer, and then it requests certain disciplinary records of certain police officers. If I could work backwards through those.
Can I interrupt you for 1 second?
Yes, sir.
It's my standing motion. As I always said, if I'd have to make it clear every time, is that there will be no recording, video, or audio in this courtroom. Go ahead.
Understood. The request for disciplinary records. Louisiana courts have already ruled that individual employees have a reasonable expectation of privacy in their disciplinary records. We cited that case. It's East Bank versus Crossan, a very similar case. In that case, the court held that fire officers had a reasonable expectation of privacy in their disciplinary records, and it was not subject to production. Similarly, Louisiana Revised Statute 44:3 provides that certain information is also exempt from production. It includes in that list security information and training information. Louisiana's Attorney General has already issued an opinion, which we cited, saying that training information of officers that do training is protected from disclosure under this statute, so it can't be disclosed. And third and finally, there's request for police policies. We're not exactly sure which police policies, so we can't respond, in specific, as to which policies were requested. However, under that same statute that we talked about, the Louisiana Revised Statute 44:3, the Attorney General has also said that certain police policies are exempt from disclosure under that same prohibition of training techniques, aids, and security information. Anything like that is not subject to production under 44:3.
All right, Mr. Hines?
Yes, sir. I have a response.
Now, you had actually submitted, I believe, a written response, as well. You filed that on March 19th.
Yes, sir. I also wrote out the response that I'd like to read.
Sure, go right ahead.
May it please the court. I object to the City of Natchitoches' motion to quash subpoena Owsley's tecum and combines motions for a protective order. Police policies are matter of public concern and information. They are used by public officials to interact with citizens. Police policies are publicly available in the neighboring cities such as Baton Rouge and New Orleans, possibly even Alexandria. I didn't get a response. Some information contained in the police policy that contains sensitive information can be redacted. However, the police policies in its entirety must not be redacted. Sections about how police make arrests, communicate with public, conduct themselves are not sensitive sections and have a public interest. The City of Natchitoches is making a blanket statement that every detail of the police policy is protected from disclosure. The entire policy cannot be withheld as a whole document. I request that the court evaluates and review the police policies as to what information would be protected by Louisiana Revised Statute 44:3. The court has discretion and can limit the information requested in the subpoena. The city may limit the Freedom of Information Act, but cannot limit a court on what can be used in a criminal case. The court has the authority to review the information in question. Limiting me from exercising my First Amendment rights by restricting me from filing papers, making public record requests, even if it annoys, embarrasses, or causes a burden to public employees, would be a gross violation of my constitutional rights, liberties, and freedoms. Louisiana Criminal Code of Procedure 1426A is a civil code of procedure and does not apply in a criminal court case. American citizens have the right to interact and communicate with their government and government officials to perform actions and make information requests guaranteed by the United States Constitution. Citizens have a right to record and disseminate for public consumption information about the actions and workings of government officials in their official capacity while conducting government-related functions. Citizens have a right to file Freedom of Information requests with government officials, even if the filings annoy or are burdensome. The request of the city of Natchitoches to restrict a citizen of its constitutional rights is outrageous. Therefore, I respectfully request this honorable court to sustain this objection and deny in part and grant in part the city of Natchitoches' motion to quash subpoena duces tecum and review in chambers the police policy for information which shall be provided by the city of Natchitoches to me. Wherefore I respectfully request this honorable court to sustain this objection and deny the city of Natchitoches' motion for protective order, as a statute is a civil procedure which does not apply to criminal case and would violate constitutionally protected actions of me.
Sir, your response.
Yes, Your Honor. Just real briefly, Mr. Hines raises an objection that the city produced a blanket denial to police procedures. That's correct. That's because the subpoena was a blanket request. It didn't ask for specific provisions. If Mr. Hines would have asked for specific provisions, we could then review those, and we could attempt to conduct a balancing test with the custodian. And if we are still unable to reach an agreement there, then that is right for the court to conduct a balancing test to determine what interests apply. But since we're here today, just on a blanket request, we submit that it should be denied.
Mr. Hines?
I stand by what I said. I have no further to add.
Now, what does the documents that the court provided you the other day that was left with our office? I did not look in those envelopes. Does that resolve any of your motions at all?
The training records help. Yes, sir.
Okay, so you did receive some records from the city police office?
Yes, sir. Certificates. Yes, sir.
Okay, well, my concern here, number one, is the subpoena is vague. There's no doubt about that. I don't think you can just ask for police policies, and they know what to give you. The other concern I have here is discovery in this case is limited to this case. I think you waver between a civil rights action, which is your right to file, but this is not the court to hear it in. First of all, it's beyond my jurisdiction. Secondly, it's a federal action, so I don't believe this is a 1983 action. You certainly can bring that, if you choose, but I think that's where you would be looking into that kind of discovery. I think regarding this, they made an effort to respond, and they have provided you with some training. They could have given you a blanket denial, but apparently the city police have turned in some responses to this, so I'm going to grant their motion to quash the subpoena duces tecum, in part, in that you have been provided some information. Otherwise, I think your request is vague. I also do believe that some of this is protected under Louisiana Revised Statute 44:3. Finally, I don't know how relevant it is, and my concern is the question in this case is not whether or not there was a crime committed, and that you had a right to be arrested. The training of the officers, in my opinion, is not relevant to that. I think whether your actions are relevant, whether they had reasonable suspicion and acted on that is relevant, but I don't think whether they were trained properly has ever been relevant in this matter. But, again, that could be under a different action, under a civil rights action if that's what you're doing. I'm not going to rely on Code of Civil Procedure, because you're right, this is a criminal matter, and I'm not going to rely on that, but I am going to rely on the relevance of this issue, so I'm going to quash it. I'm not going to grant the protective order, though, sir, but I will quash the subpoena duces tecum in the part that they have not already provided. You have not already provided that information. All right, thank you, sir.
Thank you, Judge.
You don't need to stay, if you don't wish to. The other motions are not concerning you.
Thank you, Judge.
The next motion is yours, Mr. Hines, which is the motion in limine to suppress certain evidence.
Yes, sir.
You had filed that on March 19th.
Okay, yes, sir. My constitutional rights have been violated by the officers over common harmless activity that any citizen can legally engage in. Police cannot just walk up to random people, tell them they match the description, cite an ID law, and then make an arrest over ID. Both the federal amendments and state of the Louisiana article sections state the limits of government intrusions on our liberties. The narrow circumstances that do allow permission for government intrusion are to be thoroughly scrutinized for prejudice under our due process rights. I walked into the Natchitoches library like I walked...
Objection, Your Honor. The defendant has, in his opening, began to testify. He's not under oath, and this is not a trial. He went straight into the facts of what I did, and this is not the forum or the procedure for that.
The concern, Mr. Hines, is that if you open yourself up to that, you are then waiving your constitutional right not to incriminate yourself under Article 5. So I'd rather you not do that if you don't want to. If you don't care about your Fifth Amendment right to not incriminate yourself, you certainly can testify. But what Mr. Benjamin is stating is correct. If you begin to testify, I have to put you under oath, and then you are then waiving your right to not incriminate yourself, which, I think that's something that's serious, considering, at a trial, it is totally up to Mr. Benjamin to prove this case. It is not on you to testify, so if you choose to take the Fifth, you don't have to testify. So by testifying today to your facts, I think you're opening yourself up, so you have to be very careful about that, especially when you're representing yourself. Usually, you would have a lawyer who would speak on your behalf, but if you're speaking it as in, I, terms, I did this, I did that. You are putting yourself, and I'm trying to keep you from doing so, to keep you from testifying when you may not want to. I'm trying to protect your Fifth Amendment right, so you may proceed. But the question you have here is what you have filed as a motion to suppress certain evidence. That's what I'm asking you to testify to. The rest is your standard defense for your case. But what I'm asking is, tell me about your request to suppress certain evidence. That's what this motion is about. And I think, specifically, what was about on your computer screen.
Yes, sir. I understand that to be able to make this type of... to talk about the circumstances that somebody else would have to step in and talk about it in my place, a lawyer.
An attorney would, yes. Otherwise you would be testifying. Well, if you begin to talk about actual facts of the case.
Okay, I'll continue and we'll see how it goes. It is well within the cops' legal right to approach anyone at any time to try and have a consensual conversation. But they had no legal authority to pursue a full investigation. They couldn't communicate a crime in the library.
Objection, Your Honor. I'd ask that he be sworn. He's testifying. This is...
You are talking about things that you did as opposed to just general blanket statements. I mean, here's the issue.
Okay.
If you talk about facts of the case, you are a witness, because you're talking about what you witnessed and what you experienced. If you do that, you are, again, putting yourself in a position to testify. If you testify, you're, again, waiving your Fifth Amendment right, and anything you say can be held against you.
Yes, sir. Okay. I'll continue. Failure to answer a question cannot constitute a criminal act. An affront to an officer's authority does not create criminal activity. Recording with a camera is not a crime. Being weird is not a crime. The evidence that has been collected is tainted, and the court must separate it from this case and separate it. And I'll stand on my motion.
Okay, Mr. Benjamin.
May it please the court, Your Honor, with respect to the document that Travis Hines submitted to the court, I'd call attention to page 2 of that document. He indicates, based upon information and belief, the defendant has been denied access to witness statements. The court would be the state would vehemently disagree with this particular statement and that witness statements were given to him, as well as video. And the court, to cure any prejudice that might have occurred from the late offering of that document, the court gave a continuance. So any decry that his rights have been breached by that we would contend are erroneous and out of place. With respect to number 6, the defendant believes that it is the intention of the city prosecutor to attempt to use the post-arrest witness statements to create a false impression that police were acting on these.
Well, I don't want to interrupt you, but we're arguing under the first motion he filed. He filed 2 motions. This was the one to suppress that was filed on March 9th, which is certain evidence, meaning that was seen on his computer screen by the officer at the time. That's what this first motion is. There is another motion.
Does he have a copy of that? Your Honor, he's filed so many motions, and I think we lose track of what is actually before the court.
This is the motion in limine to suppress certain evidence and set a suppression hearing.
I don't know that we received that.
That would be.
Do you have a copy of it?
This is my copy. I haven't written on it, so you're welcome to look at that. That is the motion that he had filed previously on March 9th. We do have the third one that you were talking about, the witness statements, but that's the second one or third one we're going to deal with today.
That is on for today as well?
Yes.
Your Honor, with respect to the motion in limine to suppress certain evidence and set a suppression hearing, which, in my estimation, basically mirrors the document that I was speaking on.
It does. The only difference is, he's addressing what he's asking to suppress is the officer's testimony by what was seen on his computer screen at the time of arrest.
Your Honor, our response to that is quite simple. Evidence is evidence. The time and place to challenge that particular evidence is in the court of law as a factual determination. There is put forth nothing that shows that, first of all, a detention was illegal, and therefore information that flowed from that became illegal as a fruit of any kind of poisonous tree. He has not shown or articulated any fact that would suggest that the police didn't have a right to be where they were. They were summoned to that place. So in order to suppress something, he would have to show that there was some illegality that occurred prior. There is no evidence of any illegality. This court has not previously ruled, nor has he articulated anything that would show illegality. Therefore, the motion to suppress is not proper at this particular point. And we would go on to continue that whatever evidence was garnered by police at that particular location is evidence, and it's to be weighed by the trier of fact to determine the credibility of that evidence. Phelps have an opportunity to cross-examine. He'll have an opportunity to see and put forth whatever witnesses he wants. What he cannot do is try the trial before the trial, and that's what's happening here at every stage.
And that is my concern. And I think that we discussed this at your last motions, as I don't want to try it on a motion and then try it again as a trial. I did not deny some of your previous motions. I delayed them in case you want to raise them at the trial. Regarding this particular bit of evidence, it's not been put into evidence yet. My thought is, the general rule under Code of Evidence 403 is that is something probative or prejudicial, meaning that is it valuable or is it not valuable enough but damaging to you in a prejudicial way. Since there is no jury, it comes to me. It just comes to me as trier of fact. So my concern is I don't have the evidence in front of me, so I don't know if they'll even raise it. So my thing is I think you're premature, again, in arguing this. The only way that it wouldn't be is if you can convince me that there is a question of whether or not the statute they arrested you under is unconstitutional. I've already ruled that I do not believe that statute is unconstitutional, and so I think that they had a right to do what they did. Now whether they acted under reasonable suspicion, that will be proven at trial or not proven at trial. Whether your actions warranted their arrest will be an issue for trial, but at this point, I would say I'm going to deny the suppression insofar as that it hasn't been raised, and I don't think there is a constitutional issue here as to whether or not this was taken illegally. If it happens that the officer's testimony relating to what was on your computer screen comes up, I would imagine that they'll argue it was done in plain view. I don't know that, but that's what I would imagine, and so I don't think it was unconstitutionally taken from you as a search or a seizure. I think it was in plain view. But again, it hasn't even been brought, so think you're premature on that. Now, at the trial, if they seek to bring this up, you can re-argue then that it's inappropriate for some reason. You can do that, or that it's not worthy of me listening to, so I'm going to deny it at this time, but not dismiss it outright. That you certainly can bring it at a later time. But, I mean, that's the statute under 703. Anyway, the second motion or the third motion we have today is the motion to suppress witness statements. Now I don't know if you have a second argument on that. You're welcome to present that as well.
I'll stand on the motion.
Okay, on this one, you are arguing, if I'm right, correct me if I'm wrong, that the witness statements that you've been provided should be suppressed. They were not offered at this time. I think you have actually received those, so I don't know if that resolves some of your issues with it. You have received or had access to the video statements that those individuals made, as well as a transcript, I think, of one of them. So I don't know if that has solved this issue or not. You tell me.
Your Honor, I would like to suppress them.
Okay, why is that?
They're poisonous fruit from the poisonous tree. It's illegally obtained evidence.
And you're saying that because you feel the arrest was unconstitutional still?
Yes, sir.
Well, again, I don't think the statute's unconstitutional. I'll make a determination if the arrest was or not when full facts are given to me, meaning that when we have a trial, and the officers testify, and you testify, if you testify, they testify, and any witnesses testify, you don't have to testify. But if they present a fact situation where it was inappropriately obtained, yeah, I could agree with that. But I don't also believe that the statements are going to be brought at court. I imagine that the actual witnesses will be present. So I think the statements, it may be moot that you ask to suppress these witness statements, because I don't know that they'll actually use the statements. I'm certain that Mr. Benjamin, more than likely, will present the individuals. If he doesn't, then you could, at that time, argue they should be suppressed, because those individuals aren't here and you can't cross-examine them. But again, we're getting way ahead of ourselves because that hasn't happened yet. We haven't had the trial yet. We will, but at that time, if he attempts to bring in witness statements without the actual witnesses, you can argue that they be suppressed at that time. I haven't read any of them, so.
Yes, sir. I would request an update on the witnesses who are to be called by Mr. Benjamin.
He has the right to produce that to you. If there's any changes in your original discovery request, did you provide that when y'all originally talked about that?
Judge, we provided all the witnesses to him. What I have not seen is a reciprocal discovery from him. He's not answered any reciprocal discovery. The defendant goes through great lengths to promulgate and pump out all kinds of motions, but he can't rightly respond to ours.
Okay, so what he's telling you, Mr. Hines, is there are no other witnesses than the ones you've received, so you have a list of all the witnesses he intends to call. His next question is, did you respond to his thing? I know he set up a Dropbox or some email address that you could provide him anything you plan on bringing.
Yes, sir. I'm unaware of this Dropbox address. We discussed email.
Yeah, an email address. Did he give you an email address?
Yes, sir.
Okay, have you provided him any of the discovery that answers he needs? In other words, he sent you written discovery. Did you provide him with anything that you plan on introducing at court?
I offered to meet. He's made it clear he doesn't want to meet off the record. And I sent him links to the YouTube videos. I asked about his Dropbox in the email.
I mean, my question is, he's just like you asked for stuff from him, and he gave you a file, or disk, or whatever. He's asking that from you. He has a right to ask if you plan on introducing evidence. He's not saying you have to. He's saying that if you plan on it, there is no surprises here. Just like you have what he has. If you plan on introducing evidence at your trial, you have a right to produce that in advance.
Yes, sir. I don't plan on surprising him with any evidence 2 days before the trial. I have nothing to...
Well, my question is there anything that he needs to see prior to the trial that you plan on introducing?
No, sir. I responded to his email. I don't know if he's able to see them.
Do you have anything in your email address, Mr. Benjamin? Have you received anything?
Judge, I'm not certain what he's even talking about. I think he responded, "You can find this by going somewhere." That's not how this works.
Right. If you plan on using something at trial, just like I would not want him to bring a video that you haven't seen before the day of court. So he has a right. If you plan on introducing a video or a document or witnesses, he has a right to examine those prior to the trial.
Yes, sir.
So, if you do have to produce it. You don't have to prove his case for him, but if you plan on using something at trial, you need to give it to him in advance.
Yes, sir. I understand that.
And have you done that?
There's nothing I'm presenting.
So you're not presenting any evidence at trial?
Sir, I turned in a thumb drive at the clerk's window that I was given by Mr. Benjamin of his videos.
Okay.
And the call and...
So you're going to use whatever he uses?
Yes, sir.
Okay, so there's no other evidence besides what he gave you that you plan on introducing?
No, sir.
The reason I ask that is because, and I'm going to bar you from bringing stuff at the last minute. So what I'm saying is I want this all done early because the trial date is not until April. I don't want either one of you coming up on the day of trial or during the trial saying, here is this. That's not how it's going to work. Just like I expect Mr. Benjamin in because he gave you those documents late, those videos late. We continued the trial, because I don't want you to be surprised either. So what I'm saying is when we come to trial, it's a well-oiled machine. We go to trial, so if you don't plan on bringing anything or using anything else besides what Mr. Benjamin's provided to you, that's fine. That's fine. Then that answers the discovery issue, Mr. Benjamin. He says he's not presenting anything else.
Thank you, Your Honor. So I expect that nothing will be presented by him other than what we present?
Correct. Nothing. He's saying that your discovery is his discovery. He's not going to bring any other videos or any other evidence, apparently. That's what you're telling the court today. Is that right, Mr. Hines?
Yes, sir.
And you can. I'm not saying you don't have to. I'm just saying if you intend to bring something like that to court, you need to provide it to the other side in advance. There are no surprises in court. So you don't have to do anything. You don't have to do anything but sit in that chair and make him prove his case. That's the beauty of the Constitution. You don't have to do that. But if you intend to, you need to do it in advance and let him know what you plan on bringing.
Yes, sir.
And you're telling us now that you're not bringing anything, and so he doesn't have to worry about that.
Correct, sir. I don't plan on bringing any evidence.
Which was the one he gave you?
Which is the one he gave me, and I can play it on a laptop at some point in the trial.
However you present it, it's yours, I mean your business. What I'm talking about is I'm just making sure that everything's been exchanged, and Mr. Benjamin will have seen whatever you intend to bring. Okay, well, that answers that question. So all discovery is complete?
Yes, Your Honor.
You provided the statements you did the other day. You had a chance to look at them. Mr. Hines isn't bringing anything else, so I believe all discovery is complete, and we are ready to proceed on the 11th. I think it is.
Excuse me.
April 11th.
Excuse me, sir, I request to deposition the witnesses before the trial. If I could get that permission to deposition the witnesses.
In a criminal matter, usually, that's go ahead, Mr. Benjamin. He's made a motion for a deposition.
So I think that the defendant confuses criminal procedure with civil procedure. In a criminal matter, there's a right of confrontation in the Fifth Amendment, so he 90.09 cannot have a deposition of the witnesses. That's essentially having a trial outside of a trial. It's just not germane to the proceeding. I thought we indicated we were finished with discovery, and we're ready for a trial.
Right, that would be part of discovery. And again, what he's saying isn't a civil matter. You can take depositions of people. You can take depositions of witnesses. In a criminal matter, no. You're free to contact the witnesses and talk to them. You can do that, as your lawyer, but you can't depose them.
And, Judge, I would that the state's witnesses are the state's witnesses and given the past practices of the defendant. I'm not so sure that it's a safe thing for him to be going and trying to talk to the library people. They're afraid of him. So I don't want him to further intimidate them. He's done as much as he needs to have done at this junction. That's all documented. So the bottom line is we're ready for trial. We could have it today so long as I could get the witnesses here. We're ready to go and put an end to this one way or the other for the good of all of the people concerned.
It is set for the 11th, so we will keep that date. So again, I'm going to deny your request to take a deposition in that it is a civil request, and this isn't a civil matter. It's a criminal matter, so you don't depose people in criminal matters. It's just a point of law.
Yes, sir, and it's still okay to contact them?
Judge, I'm going to object to this. We spent an entire day trying to limit the defendant's publication of things relative to the witness. This is about to be a bad situation. If he contacts one of those witnesses and goes over there, there's going to be a problem because, again, one of the witnesses is vehemently intimidated and afraid. I can't be so sure what grows out of this. He has the information he needs, and we can have a trial.
What is it you feel a need to contact the witnesses about?
Sir, I'd just like to, I haven't been trespassed from the library. This idea of them being scared of me, I'm not familiar with.
I think you're pretty familiar with it. I mean, we did have a hearing about that, and how they were intimidated, and how they have issues online that we to worry about. So I think you are familiar with that. I don't think you are unfamiliar with them being concerned about you or people who have followed you and are threatening them or contacting them or supposedly putting their information online.
Judge.
So I think you are familiar with that. This is not a surprise that he would ask this, right?
I'm talking in a different context, as in my interactions with them at the library. I have not been trespassed, and the witnesses I've seen on a daily basis practically.
To their credit, they have not asked that you be banned from that place. To their credit, they have not asked for it.
And for what questions I might ask them? I have trial questions.
Judge, we're again. He's in his head now. He thinks he has the green light to go harass these people. If they make a call on him, again, and something else happens, it's all on him, because they don't want him around them, and he created this. He's created this situation.
The problem I'm having, Mr. Hines, is simple, is that you're acting as your own attorney. Normally, your attorney would have a right for your attorney would have a right to contact witnesses. The problem I'm having here is that, let's say this was a violent crime, I know it was not, would I allow you, or as an individual, would I allow a defendant to go contact a victim? The answer is no. So if I'm in a situation where they've already explained to the court through Mr. Benjamin that they're being harassed, and they're being intimidated online, then my concern is I can't allow that. I can't allow that to happen. That's not fair to them as a party or a victim or a witness in this situation. So I'm not going to allow it, because you are your own attorney. If you were not your own attorney, and you had an attorney, I would say, yes, your attorney has a right to contact them. But I don't think that's fair to an individual individuals who have already expressed concerns about online harassment, intimidation, etc. You have not had a hearing on that or a trial on that. But it is clear that there has been, and you say, uncontrollable people contacting them online or at least posting information about them online. So I'm not going to allow it, and I'm not going to allow it based on that fact that I don't think it's fair to them. They have rights as well as you do. We're trying real hard to protect your rights. I do have to look out for their rights as well.
Yes, sir. So if I got an attorney, then that would be okay?
That attorney could contact them. That's certainly part of an attorney's job.
Okay, yes, sir.
But I'm not going to allow you to directly contact them considering what has already gone on in this case, considering the things that have already been this case and argued in this case about harassment. And I will tell you, if it is one portion of what they do to everybody in this entire system, including this courthouse, it's unnecessary. I don't know why people feel a need to call and harass government offices about this. I don't, and I know you say you have nothing to do with it, but obviously you're not stopping it. You're not. It's gone on since this started. There was a call this morning to this office saying the calls will stop when your charges are dropped.
Yes, sir.
I know you had nothing to do with that, but someone does, and I'm assuming you're not using your platform to tell people not to do that.
Yes, sir.
Are you?
I'm reporting, sir. I talk about my feelings.
My question is, do you make an effort to tell people not to harass?
I
mean, I'm telling you from the bench.
I can't.
He's told you from his position. We've had other people say it's a lot of harassment going around, and I don't care. I'm a government official. They can call me every day they want to. That's my job. But what I'm saying is, what's the point? And are you doing anything to stop it?
Sir, last night I was told I'm going to get arrested after this hearing is over.
By who?
The police over...
The police contacted you?
I did contact, and they said they had no arrest warrants, but...
Who told you were going to be arrested?
It was a stranger online.
That's not the police, then.
No, it's not, sir.
Okay.
But...
Then why would you believe a stranger online that's going to tell you something? Why not contact the law enforcement?
Yes, sir, I did contact law.
And what did they tell you?
There's no arrest warrant.
How about that? So maybe they're a little more trustworthy than the person that you don't know on the internet.
Yes, sir. Overnight, the police department wasn't open, so
Right.
I was scared. He has, in the past, other cases, has been credible, this person.
Other cases not being this one?
Yes, sir.
I mean, do you want me to hold you accountable to other cases? They have nothing to do with you. Your case is your case, and that's it. But my thing is, why not take your platform, your effort, to tell people to lay off? Why not?
Yes, sir.
Do you think it's right what they're doing?
Sir, I communicate my feelings about this situation.
Do you communicate feelings about what you think people should be contacting or harassing?
I don't tell people what to do and what not to do. I communicate my feelings and what I'm doing. It's a channel, it's not a news channel, it's a blog. It's about...
So it's not media?
It's not media?
Yeah.
It's on YouTube. I mean, it's a platform to express yourself.
Okay, I'm just curious if you have any intention of telling people not to harass people in this situation.
Sir, if there's a message that the court would like me to...
No, I want this on your own. If you think it's necessary to let them keep doing it, clearly, you do. But you have a platform, and you have a voice, and you can share your feelings. I'm just curious if any of that would be involved in saying let this play out as it is in the court of law and not all this other stuff.
Yes, sir. Would this be measured in some way?
No.
You're just asking...
No. I'm just talking to you as an individual.
Yes, sir.
Who says he has a platform on the internet in which people follow, and they share their feelings. And I'm just telling you there are a lot of harassment that comes out of this. It doesn't affect me. Let me tell you that. It's my job to be up here. People don't have to be like me. I didn't judge for a beauty contest. I'm here to weigh facts and evidence that he's going to produce and you may or may not produce, and we'll have a trial, and we'll figure it. But, at the end, all this other stuff, what's the point of it?
Yes, sir. People are attacking me. There's different people who attack different people however they do it. It sounds like some people are supporting the prosecution, but there's a lot of opinions. They're not all experts, I understand. They don't have titles as a police officer or a government official.
Right.
But we're learning a lot through this process. This is a learning process, and it's a legal learning process. I have a niche market with this channel. I only discuss criminal topics when they come up. I prefer not to put any videos on this social media platform, but issues come up. I have other channels, a travel channel, which I've neglected because I'm not traveling.
You should go travel.
What's that?
Maybe you should go travel.
Maybe I should go travel.
My position again is, I'm asking you, if you feel like it, not in order of this court, but if you feel it's necessary, you could maybe share with your followers that it's unnecessary to have to attempt to intimidate or to harass people. I'm not on you, but you've told me you have nothing to do with it, but I'm certain you're in contact with them, and you have the ability to reach them. That's your choice. This is America. Your choice as to whether you do it or not, but I'm just suggesting, if you have nothing to do with it, unless you think it's a good thing, why not reach out and tell them to stop?
Yes, sir. I'm taking a neutral stand on this. I'm not telling people what to do. They make their own opinions and take their own actions. I'm trying.
Well, then, that answers my question.
I'm taking the middle ground, sir.
That answers my question. You're not going to take a stance on it. That's okay. That's fine. You do as you wish. So we have completed our discovery as I said earlier, and, you have the opportunity if you have an attorney. That attorney can contact those witnesses. I'm not going to allow you to contact those witnesses directly because of prior intimidation that's occurred, whether with you or whether other individuals have done so with these folks. So I'm not going to allow that. You have a right to cross-examine every witness that comes before this court, whether it's an officer or whether it's a private person. You have a right to cross-examine every one of those people. And we have our trial date set for April 11th. I don't have any other motions or hearings pending. I'm going to deny, again, and delay your witness suppression statements. As I said, again, I'm denying it today, because I don't think they're going to be used. If they are, you can re-argue your argument at that time. And I think that's the last motion we have unless you have anything, Mr. Benjamin.
I do not.
All right, then I think that's concluded. So we are concluded for today, and we are still set for trial on April 11th, at 9 o'clock.
Thank you.
Thank you.